Good evening, ma'am. Garima ma'am, are you there?
Yes, I'm here. Yes.
Ma'am, myself Vaikashri from the Department of Sociology.
Nice to meet you.
Thank you, ma'am. And I hope we can start, ma'am. It's already
Yes, please, ma'am. Yes.
because we don't want to lose your valuable time.
No, ma'am. Thank you. Thank you so much. Yes.
Okay, ma'am. Thank you. Okay. And then, Gauri, I think we can start.
Good evening, one and all. Respected Principal, Head of the Department, PG Department of English, distinguished guest, Dr. Garima Tiwari, and all other members of academic fraternity. Myself, Nandana, host for today's event, is extremely honored to present before you the topic of the event, that is IPR and Traditional Knowledge in India. As we all know, IPR, which is intellectual property right, is the basic foundation that guards the creative, intangible creations of the human intellect using systems like patent, copyrights, trademarks, etc. Well, in the upcoming context of National Education Plan, which is of the 2020 plan, it is pertinent that the students of the higher education are made aware of the same. Well, this is our session's topic. Before going to the topic, first of all, let's pay our homage to Almighty as well as our visionary, Sri Manat Padmanabhan. Now, for that, I invite Rashmi for the prayer as well as other Smarana.
നിൽക്കുന്നു ഞങ്ങൾ ഈ പ്രപഞ്ചാതി നാഥന്റെ മുൻപിൽ സുപ്രമോദം ഉണരട്ടെ മണ്ണിൽ സർവശക്തിതൻ സംഗീതധാര അന്തിവാനം ആനന്ദ ജ്യോതിസും ബന്ധുരാമ ഉഷസും തപസും അന്തഭൂമിയിലെ ഓരോ തരിയും ചിന്തിതാനന്ദമേ നിൻവിലാസം. ആചാര്യനുസ്മരണം. വന്ദേ ശ്രീധര തൃപ്പെരുന്നയമരും ശ്രീപത്മനാഭ പ്രഭോ വന്ദേ ശ്രീധരി പാർവതി പ്രിയസുതം ആചാര്യതേ മംഗളം. വന്ദേ ഭാരത കേസരി സുമദേ കാരുണ്യവാരാനിധേ വന്ദേ ഹൃത്തട പത്മമധ്യസുലസൽ ആചാര്യതുഭ്യം നമഃ.
Thank you, Rashmi. To welcome is to show honor. To welcome is to establish integrity. Now, for the welcome address, I invite Vaishnavi from Second MA.
Good evening, all. I'm incredibly honored to welcome all of you to today's lecture on IPR and Traditional Knowledge in India, conducted by the PG Department of English, NSS College, Pandalam, in association with IQAC. First and foremost, I would like to welcome our principal, Professor Dr. Sanat Kumar, in his absentia, our beloved head of the department, Dr. J. Anjana, and all other faculty members, students, and whole academic fraternity. Last but not the least, it is with such a delight and joy I welcome our esteemed guest for today's evening, Dr. Garima Tiwari. She is the Associate Professor at School of Law, Bennett University, Great Noida. She also holds position of Assistant Dean of Admission and Outreach, Assistant Dean of Research and Consultancy at School of Law, Bennett University. Previously, she has worked as Law Associate, Faculty Department at the National Judicial Academy and a Senior Researcher with Lexidale International Policy Consulting. She has a PhD from the University of Camerino, Italy, with full scholarship and was a visiting researcher at University of Oxford and University of Copenhagen. She has an LLM from Turin in collaboration with United Nations. She did her BA LLB from National Law Institute University, Bhopal, where she was awarded Pandit Ram Lalji Sharma Memorial Award in 2007. Dr. Garima was awarded the 2009 Justice Makers Fellowship by International Bridges to Justice, Switzerland, on criminal justice reform and was also given the 2016-18 Equality Knowledge Research Grant awarded by Eastern Michigan University. She has been invited as a guest and visiting faculty at Indian Institute of Management, Rohtak, V.V. Giri National Labour Institute, Delhi, Rajiv Gandhi National University of Law, among others. I'm extremely privileged and grateful to be in the presence of such a visionary scholar, and I once again extend my warm welcome to you all. Over to you, Nandana.
Thank you, Vaishnavi. Now it's time to pay attention to our speaker. Let's all be very attentive throughout the session. Now I welcome today's speaker, Dr. Garima Tiwari, to please proceed with the lecture, ma'am.
Thank you so much. And I think, thank you, Gauri, thank you, Vaishnavi, and all the participants here. I would like to first start by thanking the PG Department of English, NSS College, and also the IQAC team for this wonderful opportunity. Dr. Harita for actually connecting with me and just arranging for and coordinating for this talk, and Dr. Rekha Shri for coordinating here, and also Principal Sir and Anjana Ma'am who is present in the talk today. So while we were discussing, and I think Reshmi, what a wonderful rendition. I think the topic of today's talk gels well with the idea that you've just presented something in a traditional form. And this is where we are going to take it forward. So thank you so much. What I'll do is I'll share the slides. I usually don't like using slides much, but I would still share it because it has certain components of law. And therefore, I thought maybe using the slides will align you with the terminologies that are used in law. So let me just share it. It's just going to be very quick. Yeah. So the topic that is with us today is intellectual property rights and traditional knowledge. And all of us today are aware that our traditional knowledge is something that we are very proud of, and we definitely use it wherever possible. At our homes, when our parents are using some sort of traditional medicine, we think of it as something which is very normal to us, which is very common to us, and our grandparents giving us certain forms of food, things that we use in our culinary items, or anything that we are using in our folklores. We think of it as something which is very, very simple, something which may not be relevant for people in other countries, or which is a part of our life. However, the topic today is traditional knowledge, and therefore I thought that I'll introduce you to this idea that is a part of our life, yet has been misused and has been taken for a special purpose by other countries and probably by the commercial organizations. So I'll just introduce you first to this idea of traditional knowledge here. For all of us, it's very important, and we all know that there are certain types of information that we are acquainted with from our very childhood. When we are given stories from our parents, or you sit and attend certain prayers, you realize that there are certain oral and intergenerational aspects of understanding that we go through. So that's passed down through generations. Then there is something which is very diverse and widespread. So we are aware what to take as a traditional medicine. We know certain practices of agriculture which are so common to India, which may not be found elsewhere. Certain types of crafts and technology, food, nutrition. And then there are also aspects pertaining to what we do as a community. So where we live, in our villages, in our hometowns, there are certain cultural practices and customs. I'm aware that the sociological understanding of customs and traditions is different. Legal understanding is different. And when you move towards international law, it again becomes very different. And again, when we will see through the slides and when I will explain further, you will realize that the knowledge I'm talking about is not purely in terms of its content, but how it is expressed. So when I'm saying that this is a book which has certain knowledge, not merely the book, and its content, but how it is expressed is also something which could be used and misused. And therefore, this traditional knowledge which we have over time came into the domain of seeking protections, and that's why law had to interfere in it. Now, if you see why I'm talking about this, like I said, we have to safeguard certain traditional practices, certain aspects of our wisdom that could be local. Now, while we're emphasizing on India, each country has its own way of protecting these aspects and each way of promoting these aspects as well. So if you see combating biopiracy, this is the first point I've written. And this is where all of us really need to understand that the commercial organizations, they end up exploiting a lot of our traditional knowledge. We may not necessarily realize it, but I know that in Kerala, there has been a very good IP policy, which I'll briefly discuss later. However, there's a lot of unauthorized appropriation, commercial exploitation of our knowledge. Then again, our traditional groups or our indigenous communities, they need to be empowered because they have a lot of knowledge which is actually their own. And we tend to use it thinking that, it's something which is very normal and we could use it easily. This term biopiracy is something which is very commonly used nowadays, and in particularly in legal books also, where you use the aspects of nature and the knowledge that is there with indigenous people without their permission and without giving them the benefits or financial gains because they have developed and nurtured it. And a very important aspect of traditional knowledge is also aligned with the idea of cultural heritage. Now, again, cultural heritage is something which has a very wide scope, and different international organizations have also emphasized this need that we really need to protect cultural heritage. If you see the current wars that are happening, a lot of times countries target these traditional buildings, educational institutions, museums. And these are the places which actually are the hosts of this traditional knowledge sometimes. So all of these reasons point to the fact that we really need to protect our traditional knowledge. Now, and how do you protect it? So there could be a formal way and there could be informal ways of protection. At the beginning of the talk, I said there are ways in which we informally protect it. That is when our grandparents are telling us some simple thing about what to use, what not to use. Our communities are talking about how to stay safe. What are you going to do in terms of prayers? What is the customary law that you're going to use in particular event that is happening? Different marriages having their different customs. So there are certain informal regimes which govern this use and transmission of traditional knowledge at community level. So each community has its own traditions and customs. And then over time, when you repeat it, in law also we end up saying that there is a way in which you repeat the practice over time and it ends up into custom, and customs then gradually take the form of a law in a society. And then usually if you see this informal protection is monitored and enforced by our elders, the spiritual and religious leaders, or anybody who has been tasked with this protection. It could go back to very traditional systems. Now, this informal protection seemed not enough because these protections remain within the community. Like if we're doing something in our home, we can pass on the knowledge to the children, or we get the knowledge. However, what happens is the protections are only limited. If somebody misuses it, we cannot do anything about it. And that's where you have this formal system. Now, I know the slide is a little cluttered, but if you see here, I've pointed out why intellectual property rights come into play. So like we saw that intellectual property rights, they are certain legal rights. That means now you're actually codifying everything that this is my particular right. When I'm singing a song, this is a particular thing which belongs to my tradition, and therefore I should be protected in singing it. And if somebody misuses it, so we've seen a lot of stars and musicians end up using those traditional songs and then cases coming up. That's where you have this traditional knowledge being protected. So they say that the inventor creator has to protect the invention for a certain period of time. There are several laws in place for this. We have the Patents Act. Okay. Now, Patents Act itself, patent is something when you create something new, it has a novel use, it is original, And therefore, you have to decide whether or not something which is in our tradition could be given this patent, because it is something which is not new. It is something which is already in place. So Patents Act, which is a law of 1970, it is excluding the inventions which are based on traditional knowledge from patenting. That means today, and I will give you examples, if today let's say a spice that you use in a kitchen, some foreign company comes in and says, this is a spice which can help in curing cold, they cannot patent it because it's something which is based on traditional knowledge in India, and we are already aware of it. And like I said, IPR policy of Kerala of 2008 is actually giving this form of formal protection. It says that there is a domain of common knowledge. That means all of us know it. So it seeks to commit all the traditional knowledge to the domain of knowledge commons and not to public domain. The community or family custodians will have the right to this knowledge. Those belonging to them, that means if I have a family structure, I have the right to that knowledge and I can pass it on to somebody else. But if there is some traditional knowledge which is not family-based, community-based, it could be owned by the state. Now, similarly, apart from Patents Act, there is Copyrights Act, which will help you protect all the literary, dramatic, musical works, folklore associated with the traditional knowledge. I will give you example of folklores as well. And then there is this Biodiversity Act, which is telling you that how you can protect your plants, etc. There's a bill which is pending. We'll not go into that right now because it'll take a lot of time. But if that bill, which is of 2022, if it comes into light, that we might have a very formal system. So there are two structures right now, formal and informal. And because the informal structure was not very helpful, we had to move towards this formal structure. Now, a lot of initiatives have been taken by the government. This is one of the most important initiatives, the Traditional Knowledge Digital Library. And it is appreciated by the world and the World Intellectual Property Organization also, because India is one of the country which has been able to create this repository where you are depositing a lot of documents. And now the problem with initially was that we could not document a lot of things. Like if somebody tells you a story or a folklore, unless and until it is given in the written form, it has an idea, you can prove that it has been used for traditions and centuries. You really cannot say that it is a traditional knowledge. So over time, you have to start collecting that evidence to seek protection. So this is one part, Traditional Knowledge Digital Library. Then there are geographical indications. For example, the Kanjivaram silk, Darjeeling tea, and Tirupati laddu. All of these things have these the geography attached to it. And these indications are considered GI tags, which are given to the products which are from a particular place. And they've also come up with these community biodiversity registers, where I can go and actually deposit any knowledge which I think would be pertinent with the bioresources. Now, with this, I'll just quickly say that these are the challenges I was already talking about. New generation may end up saying that, no, this knowledge is not relevant. I would prefer to use medicines which are maybe, let's say, more available in a store rather than buying certain traditional things. That is something which can lead to a problem where traditional knowledge may not seek protection. There's lack of documentation, like I pointed out. IPR laws are sometimes very rigid. I might have to prove a lot of things, and traditional knowledge may not have that support structure. A lot of us may not be aware how to go about actually protecting our traditional knowledge and what would actually be falling under that category. Again, the customary systems, like I said, within the home, you can protect something. Within the home and your family and your lineage, you can actually go ahead and transfer it. But then outside the community, if somebody wants to misuse it, you really can't do anything about it. And IP mechanisms fail in using this undocumented aspect. And finally, there is this idea of acculturation and diffusion. Now, this is something where, let's say I today go somewhere else and I try to modify my culture. Now, I'm generalizing right now, but then in acculturation, somehow the actual knowledge diffuses, it becomes something which is specific to the other culture or just dilutes itself. And that also leads to certain problems. And IPR then has to really struggle. The intellectual property law has to struggle as to what is the correct form of this knowledge. Because it could be vernacularized or it could be made something very, very different as it goes to some other place. And then you can find different versions of this traditional knowledge. I'll again take you through some examples here now. Like I said, that you have this formal and informal system, and we are going ahead with seeking this protection in the forms of library. There are certain success stories which we have in our country itself. A lot of you may have heard about the fact that neem has, we all know that neem has medicinal properties, and I think most of us who is aware of its medicinal property, it is known as a miracle tree. It is used for several things in our home. Now, a US company went ahead and decided to patent it in 1994. Now, some saying that for patenting, you need something to be new with a novel usage. So when they patented it, India was like, this is something so common to us. It's not something which is new. It is a part of our culture. It's so traditional to us. And so the government of India, along with several groups, even Vandana Shiva and all of those NGOs, they had gone there. They had actually challenged this patent. They said that there is prior art and traditional knowledge of this name. Prior art implies that there's already existence of something on similar lines in our country. You don't really need to commercialize now and say that buy this neem product at a certain cost. So what happens when you have a patent? So let's say I get a patent on neem. Now, in that case, if you need to use neem, any one of you, you will have to purchase it from me, or I will be selling it to you at a cost. However, because it's traditional knowledge for us, we all have been using it. We don't need to pay somebody to use it. So that's where the government of India and the NGOs could actually set this precedent where neem patent was revoked. So that was the first success for India. Similar to that, you know, turmeric, like I pointed out, spices. This was a very landmark case where in 93, again, a patent was filed at the University of Mississippi Medical Center. And they received a patent for the use of turmeric for a wound. Now, again, it's something so common to us. It's not something we would say, you know, we really need to have a patent on it. We usually think of these things as very common to us. So again, this was revoked. India had actually challenged it. And it said there's nothing novel about this. You cannot give a patenting right over this particular product. So turmeric patent was also revoked. So like I was pointing out, several countries are trying to take our traditional knowledge and trying to say that this is something new, and we would now like to really take rights over this and then sell it to you at a higher cost. So then you have this tradition getting commercialized. Yoga is something very recent where they want to actually have copyrights and trademarks on different yoga accessories. That is okay. Accessories can have some patenting. But Bikram Chaudhary, a US-based NRI, he actually wanted to really have a copyright on the method through which he is teaching yoga. And he said that I need a patent also, whatever forms I'm doing. So I want a patent of it. Obviously, India had a huge discussion of it, that it is something, again, a part of our culture. You cannot really commercialize it in this way and say that you need to own this particular practice. So it again went back to our cultural heritage here. Now, I'll quickly jump to this fact that I was just talking about certain plants and medicines, but folklore as such is something, again, we'll have a discussion after this, but a lot of our stories, like I was saying, when we hear, we really need to protect those. And folklore, in general, encompasses traditions, songs, customs, practices, and it is actually a part of our cultural tapestry. So it gets intertwined with our knowledge systems. Whatever I'm speaking right now, how I'm speaking, how you would behave, everything has a fact that we've learned through our practices and our knowledges. And therefore, what the fact was that for a long time, traditional knowledge protections were limited to the products like turmeric, neem, but there was also a need to protect our folklores. And therefore, several laws were brought in, like existing laws started including certain aspects pertaining to it. And we also have a Folklore Protection and Registration Act today, where folk dances, plays, artistic forms were, even if you've not reduced them to any form, they could be protected. And geographical indications, I've already told you, the Kanjivaram silk, Tirupati, Laddu, etc. Now, in this also, like I said, am I discussing it? Because people misuse it. So there's this chow dance, which is in usually Bengal and other states, where the Indian government had to challenge the misappropriation of this dance by a foreign production. Even the songs that we hear sometimes in movie, like I said, sometimes they are taken from traditional communities and projected like a new song. But you need to protect these songs as traditional forms of display of our folklore. Varli painting also, again, this painting was revived because this was misused and it was taken into a very commercial part. And that's why you see sometimes our handicraft industry is given certain forms of protection. Their cost may be sometimes higher also, because you try to protect these traditional knowledge. And a lot of times you will see those GI indicators also mentioned on those products. Now, lots of international initiatives. I will try not to go in depth into it, but just to point out that why is India doing this? Like I said, a lot of groups have been trying to misuse this information that we have and trying to seek protections in that form. And then the other part of it is that you need, the product could be same. So African culture could have the same use of turmeric. India could have the same use of turmeric. How do you align the values that you give to these products? How do you align the dance forms? How would you know if somebody is earning through it? So let's say even if India does not register it, but you have US registering turmeric, in some country you are commercializing it, the other country you are not. What is the scope of using it? And therefore international initiatives become important. There is a specific committee which is working on traditional knowledge, genetic resources and folklore. There's also certain protocol and treaty which discusses about the facts that there may be people who are visually impaired, and how do you allow them to access these resources, what are the traditional knowledge texts, etc. These are certain international initiatives. Now, I'll just quickly end with this, but I'm going to just discuss more about it subsequently when we talk further. There are certain trends today in protecting traditional knowledge. And I started with the idea that it could be misused very easily. And the fact that it could be misused is increasing because today we have so much of technology available to us. You could just do anything with that technology and use this traditional knowledge anywhere. It could be easily disseminated anywhere. And you have the tools and techniques, like all of us might be able to find some way or the other of using this traditional knowledge. Now, therefore, here comes in the concept of bioprospecting. And this is a kind of a research where what you do is that you actually end up using the biochemical or any other genetic product which is there and convert it into a commercially valuable product. So what happens? Let's say I am an industry and I see that there is a commercially viable product which is being used by this community. I go and start bioprospecting it, doing some research on it, and start claiming rights over it. Now, this could be useful for the community. It may be something, let's say there is a cancer cure out of that product. However, it was something, a part of a particular community. So they have started saying that this trend should be that even if you try to bioprospect, if you do a research on something, you should have the idea of sharing it. So you should be able to share it with the community where you are really, from where you're taking this knowledge. Again, because I told about the library, it's very important to document everything. Now, we know about our traditions and culture because there was some documentation, We have the culture of Shruti Smriti. It has been transferred to us. We can hear about it. Today, while there is a lot of documentation available, like at this moment itself, we all would find thousands of information data about one single point. And therefore, what is correct, what is not correct might be a problem. So what this blockchain technology systems they want to create is a platform where you could document everything that and then prove it through evidence. You should be able to identify what is relevant, what is irrelevant. We know about fake news, all of those things. And third, very important trend which is there pertaining to intellectual property rights in traditional knowledge is that how do you recognize the value of this traditional knowledge in global health challenges? And during COVID also, we were using a lot of homemade remedies for immunity boosting. So I think, for example, Tulsi, etc., which were being used by Indian community. So how do you actually promote this to help the international community? And therefore, these emerging trends have helped the legal fraternity also to understand that it's not enough to simply have this knowledge recorded somewhere, but also how can you really use it without taking away the benefits from the people who created it or from the country from where it is coming as a knowledge. So at this point, I will stop and we can have, so these are some of the pointers I wanted to start off with. And based on this, what I'll do is I'll take up some discussion points and questions, and then we can discuss more as to what you would want to know, because there are lots of ideas that I floated right now. So people might have some questions or queries here. Thank you.
Thank you so much, ma'am. That was indeed a very efficient lecture, very precise, leaving no room for any confusion. Thank you, ma'am. Now the platform is open for a very healthy discussion. So those who would like to ask questions, please turn on the mic and clear your doubts.
I think somebody.
Ma'am, may I ask question? I'm Dr. Krati Sharma.
Yes, ma'am, please.
Okay, I'm associated professor and I'm teaching English. So
Yes, ma'am.
how I can think about going for IPR? Like, you know, in English we have folklores for sure. In Rajasthan, I have written some paper on folklore of Gangor. So can
Yes,
I go with this idea that this is the thing which we are practicing in our home, not now, but from ages?
yes, ma'am.
And the way we, you know, worship that Gauri, and this same tradition we even see in the other state also, in Chhattisgarh also, in Maharashtra also, but they have a different type of the same worshiping, but in different name is different. So how I can think of going for IPA in this direction? Please guide me for that. Thank you so much.
Yes, ma'am. So there are lots of steps required in this protection process. Now, the thing is that for any folklore that you're trying to register, you will require certain steps and certain documentation. Now, sometimes you will not have that documentation because it's through oral traditions, and therefore you have to start collecting data on proving the fact that yes, it is actually a folklore. And because we generally use, we sometimes have an open-ended use of these words, folklore or dance, folk dance. But sometimes they may be certain versions of it, not exactly folk dances or exactly folklore. So in this case, what happens, we have this particular law pertaining to folklore in India. And I just mentioned that it was the Folklore Protection and Registration Act. The particular community which is actually using this dance or dance form or any kind of folklore, they can go and apply under this particular act, which is of 2007. There is a form which is there asking you to fill in all the details, and you have to give all of those details and then also register in the traditional knowledge directory that I pointed out. So once you are able to prove and fill that form and suggest everything, that this is how you're going to really protect the system. So you'll have to identify what are the steps. So any patent that you're granted, each part of that patent you have to define. Even in folklore, you'll have to look into history. And I'm sure that we usually do that in history classes, English and folklore discussions. We try to dissect all of its part. All of that will have to be filled in. And you will have to involve the community. Because like I said, it's not going to be simply my right over something, which is traditional. You'll have to involve the community for it. And together you would then be filling the form, telling this is the community folklore, and then going for registration. So it would be, I think it's not difficult if it is actually a folklore. They'll be happy to give protections if it's not already registered in the directory. So you can check the directory to find out also if it's already registered there.
Okay, that's a wonderful thing because we might we in our family we used to do this kind of this Gangor Puja, and then there are these
Yes.
songs for 15 days. So
Yes.
even so many families, and the history will definitely, there are the books in which it has been mentioned. So thank you
Yes.
for the direction, and I definitely go and think about it and definitely do it. Thank you so much, ma'am. Wonderful lecture.
Thank you, ma'am. And I think it's very important because, like I said, a lot of traditional things we know because we were told. But today, I don't think so. All of us may remember because there's a different kind of family structure, the society that we have. So I think recording these things properly will help us to maintain it for our future generations also.
Sure, ma'am. Sure.
Thank you.
Hello, good evening, madam.
Good evening.
My name is Abhay Krishna. I'm studying PG in NSS College. My
Yes.
question is that what actually is traditional knowledge? Like, how long does a thing need to exist so that it can be termed traditional knowledge? Like, if anything exists for more than a decade, does it count as a traditional knowledge, or does it need to have a longer time period?
Yes, so I think this question is always there in courts, and not merely for traditional knowledge, but for any custom to be proven as a custom. So sometimes, it's there are ways and methods in which you have to define what is a custom. And for example, I'll tell you in international law, we have how do you define something between, let's say, India and Sri Lanka being a custom and a similar practice that has been happening? You have to prove it that it has been practiced for certain period of time and there has been no break in the practice. And then you also have to add on to it certain versions of community acceptance on it. Now, in this case also, when you have to prove that something is a traditional knowledge, you will have to prove it over time that it has been used generation after generation. No temporal limit is given. There is no timeline that is given here, but at least it has to be something which is traditional. So if I start something today and 20,000 people start using it, it's not tradition. It's something which is a practice which is developed. Traditional knowledge has to be something which is formed an expression. And there's a definition of it also under the Patent Act, which tells you that why it may or may not be expressed in written or in documented form. So one thing, like you asked, is it like you need to have generations of it? Not necessarily generations, but you need to have certain timeline to prove that there is a tradition and practice being followed for something. And second, you have to prove a community has been using it. I alone, it may not necessarily be a tradition. It may be just simple practice that I'm using. So you have to find out evidence of community. So one, traditional knowledge being used for over a period of time, something which has not been used commercially, but it has been used generally as a part of practice of our cultures. It may or may not be in a form, or it has to have some expression. It can be in the form of a song, it may be in the form of a medicine, anything. So you'll have to prove that categorization also. And then you have to say that it's not something which has emerged abruptly. So no break in the practice. Yes, you can say that it was extinct and I've been able to find it out. Like this practice stopped over centuries because of certain wars, etc. But I've been able to find it. So that way you can rebuild that practice. So the question that, do you really need to have a timeline? There's no temporal limit, but again, you have to prove it's a tradition. And to prove tradition, again, the court, when it hears it, when you put it in the application form, you will have to identify the way in which you're saying that it is a tradition. How many people practice it? When was it developed? Which community? Which region? What is the value of it for the community? And again, if you lose it, let's say if I lose a particular culture, is it going to harm my culture in some way? Is it going to take away something which is of value to a particular tradition or a culture? So that's how you try to define it. And in social science, no specific answer. So it could be broadened, it could be limited, and courts have this interpretation right to actually go ahead with it.
Thank you, madam. Thank you. for the
Did
explanation.
I answer your question?
Yes, madam. Yes, madam. Thank
Okay.
you. Thank you.
Okay. Any other question or any comment also? Thank you. Yes.
Good evening, ma'am. I'm from NSS College, Pandalam, PG, first year. My name is Srinath Snowasan. I'm have a question. That what is the significance of traditional knowledge in India, and how we can protect traditional knowledge?
Okay. So I think, like I said, traditional knowledge is something which is getting diluted today. And because it is getting diluted, we really need to protect it. Now, significance of traditional knowledge, for example, I'm in north part of India, you're in south. All of us, northeast, west, everywhere have certain ways of life. And these ways of life involve certain things which we consider really, really ordinary to us or commonplace to us. But they may not be, because they are a part of our tradition, and gradually it is getting lost over time. Or it may be used by somebody else. So like those pattal that we use, the leaf plates, we use it normally, but I heard that some Nordic country actually tried to patent even that, saying it is something new. And it is very, very medicinal. It has a very good value to it. People eating are more healthy using that product. Now, something like that, one is to protect it, and then the other is for the other countries not to misuse it, saying that it is something very new, because you can't allow somebody to misuse that. Of course, they can use it, but they should attribute it to the country from where it has where it finds its origin. So that's the first part. That traditional knowledge in India is very relevant because India has traditions, India has value systems, ways of transmission of our folk culture and other forms. The other thing is the second part of it. How do you protect it? There is law, and it tells you how, in steps, concrete steps, how you can actually go ahead and save in terms of copyright, in terms of intellectual property law. Even if you don't know about law, you can simply go to the court and seek protection of a certain form of knowledge, which may be completely new and court does not know about it, or legal system does not know about it yet, and it could also be given protection. So law has its steps through which it protects it, and it is required particularly in countries which are very strong on tradition like India. Okay.
Okay, ma'am. Thank you, ma'am.
Okay. Yes, I think.
Gauri Chiple.
Good evening,
has
ma'am.
Good evening.
I'm Gauri from second MA English. I have a doubt. Does buying an original work mean?
I'm sorry.
Gauri, I think you should type the answer. Gauri, I think you should type the question in the chat box. Can you please? Gauri, can you please type the question in the chat box?
Does buying an original work mean we are acquiring copyright in it? So if you're buying something, you do not acquire copyright on it immediately. So let's say when I write a poem right now, I might have an immediate copyright. If I want to have a written right over it, I will have to really get it registered. So that's why in books in front of all the books, you see copyright pertaining to it, who owns the copyright. Now, when you buy something, you do not immediately get a copyright on this. In fact, the person who is selling you the product, there is an agreement between you two, a buyer and seller immediately enter into a sort of a verbal agreement or a written agreement. And therein you will have to define. So usually if you buy something traditional, it is the person who is selling you. That person continues to own the rights over that, the structure, value, the type of product. Okay, of course, you own the product, but the format of it. So let's say if you buy a Kanjivaram sari, you will not own copyright over the designing, silk, anything. The community owns the geographical indicator owns the right. Maybe somebody who wants to sell that sari, they will have to take a GI tag on that sari. So that's how it works. If you are actually buying something which is original, you immediately do not acquire copyright in it. You only get ownership of that product, but not copyright.